welcome to today's edition of Disbar, the Florida Bar. I'm your host, Les Winston. I'm with every weekday from 2 to 3 right here on The Biz, fastest growing radio station in South Florida. And we are talking with victims of the Florida Bar's corruption. My guest this afternoon is Eliot Bernstein. We're continuing the story of Eliot Bernstein. We started it on a previous show, and I want to carry on with Eliot to point out to the listening audience just how serious and how important it is for us to correct the inability of the Florida Bar to do what they're supposed to be doing to protect us from rogue attorneys. In the Eliot Bernstein case, he started out with a law firm here in South Florida, having invented a very, very powerful, very significant invention. It's been considered to be the equivalent of electricity to bring it to some sort of analogy that you can relate to. That's a very important invention worth a lot of money. And when he took it to Proskauer Rose for work of a patent attorney, they told him that they were skilled in patent work, and but that wasn't to be the case. In fact, what they did was they brought in other attorneys from other firms to do the work, and as a result of being brought in, bringing in attorneys from different places with different experiences, and they having the ability to recognize exactly what was involved here and the values, it became almost a plot. In fact, I believe that Eliot would tell you it is a plot that they hatched in order to create a patent pool around this patent to actually steal the values of the patent and use them for their own benefit in deference to the inventor. And so we were at a point in the story where we were discussing, Eliot was relating the fact that these patents, that the patent that he had invented was now being controlled in part by other attorneys who were brought in from New York. And a gentleman by the name of Utley was involved, who used to be with IBM. Is that correct, Eliot?
Correct.
Yeah, and so we were at a point where you realize now what's happening is that your invention, through the devious methods of these attorneys and the attorneys that they are combined with, are making your patent their own. They're using your patent to create other patents in their own names, recognizing the extreme value of what you had invented. And you were involved with the Proskauer Rose law firm here in Florida and several attorneys in New York, and you were at a stage now where you were losing contracts, because when you had contracts written with Warner Brothers, for example, Warner Brothers discovered that there were issues with regard to the patent ownership, or I guess the control of the patents, and they then backed out of contracts. So there was there is significant financial harm being brought to you as a result of the the contrivances of these attorneys. Take me to the next step with regard to what you then do to try to protect yourself or to remedy the situation. What did you do?
Well, where we left off was that I should preface your comments there with the fact that they brought in other attorneys, Proskauer did, when I brought them in the inventions, but they brought them in under they misled us as to who they were. They told us they were Proskauer partners when in fact they weren't.
So they basically lied to you.
Absolutely.
Yeah, it's not false pretenses; it's a lie. They said that they were members of their firm, and in fact, they weren't.
They made representations to investors in the company of that.
So people that were investing in your company were relying on the fact that Proskauer was telling the truth.
That's correct.
Yeah.
And they were surprised when they found that Rubenstein and Joao were with Meltzer Libby out in Mineola.
Right.
And then because they were caught right there, they had to, tell us that Rubenstein was coming to Proskauer, and they were, had bought out because they wanted to get into internet. And
so they were laying the groundwork to try and make it appear as if they were becoming part of Proskauer if they weren't already.
Well, I think what they did was they went out and picked the guy who could most steal the technologies for them, and then planned on bringing Rubenstein to Proskauer to control the technologies through Proskauer, which they are now, through MPEG.
Okay.
Rubenstein wasn't with Proskauer. He was working on the MPEG patent pool, which was a very small pool of patents that he was trying to create the standard for digital video. And so Proskauer saw that Rubenstein was probably the most harmed by my technology, so they went to him to patent it for themselves.
Okay.
Not for Eliot Bernstein and the investors and Iviewit.
Okay. They did it. They were doing it for another party.
They were for themselves.
For themselves, I'm saying.
Meaning, right now, today, Proskauer Rose, if you go up to their website, lists MPEG as one of their clients.
Okay.
And that Ken Rubenstein controls MPEG and was the guy who founded MPEG and is the sole patent evaluator, basically gave Proskauer the control of rolling out my technologies on a major basis. Now, this involves, public companies, Google, Yahoo,
right.
That we're going to take off. And there might even be evidence that they actually manipulated the Internet stock bubble, knowing that my technologies would revolutionize the Internet, and they drove out of business a lot of companies that were ground floor in the Internet through the bubble, gobbled up those companies that they knew would benefit from my technologies, like storage devices, whatever, encoding companies, video distribution, and then once they could buy the companies on the cheap or force everybody out of business and come out and emerge with their partners. So you have to understand these technologies now, they made new markets. For example, you wouldn't be able to do the iPhone video application. That's, the hot new thing on the iPhone without my technologies.
Okay.
That's a brand new market that wouldn't even exist without it. And so all of those markets, I think what Proskauer did was knew that Rubenstein could roll it out into the standards. They would then control the standard, and all they had to do was rub out their client, the inventor.
Right, which is what they tried to do.
Well, through car bombing in the end.
Right.
And so, and everything else. They economically deprived me. They blocked me from due process wherever I went.
Yeah.
And that'll get into that part of the story. We picked up at the last show we caught Joao patenting. We went to Proskauer.
Right.
We said, this is the guy you brought in. What's going on? Is he putting inventions in his own name, my patent attorney? This is unbelievable. And people thought we were crazy even saying it.
Who thought you were crazy?
Everybody, investors, whoever we took it to that was involved in this thought, what are you talking about? Your patent attorney's putting patents in his name? It's hard to believe.
Right.
It's probably hard for you to believe, and you're not an investor.
No, it's very hard to believe because you can't even imagine that they would consider doing something like that because it would seem so ridiculous for them to do that.
Well, you remember this. The patent office is bigger than the banks.
Right.
It's the biggest jewel of the country. So if you were planning a coup or siege on the country, you would go after the jewel.
Right.
And the jewel is the patent office, and now you can see they've got an IBM guy that Obama just put in, Capos, running the place, who's trying to make it first to invent, which would, kill all inventors as their attorneys run to the patent office first, like Joao, with your invention. And forget to file yours timely, and
So
when your attorney becomes your adversary.
Yeah, this is a huge, Eliot. I mean, I think the listening audience needs to understand that there's a reason why you are the hello.
Yeah, I'm here.
Yeah, there's a reason why you are a plaintiff in a $12 trillion lawsuit against a myriad of defendants, including all of these attorneys. Is that correct?
Yeah, and that lawsuit's tied to a whistleblower lawsuit of a Supreme Court of New York employee, staff attorney.
So what you've done is because in order to, what happens when you have a huge potential victory or huge potential claim against anybody that has clout, they mobilize every single resource that's available to them in the judiciary to protect what they've done. And this is a pattern that is probably going on around the country in hundreds or if not thousands of situations where there are large claims or where individuals have assets or where there are attorneys who are trying to get their hands on or around the values. These are rogue attorneys. Now, we're not talking about all attorneys. We're talking about the ones that specialize in this kind of behavior. And those rogue attorneys are not controllable because the entities that are supposed to control them, as we've learned from what you just talked about, this whistleblower, they have a systematic way of diffusing complaints against these attorneys or against judges who do things that are outside the scope of what is legal. And just correct me if I'm not paraphrasing all of this in a kind of in a correct way. This lady Anderson, who worked for the Justice Department in New York, in the state of New York? No?
New York Supreme Court.
In the New York Supreme Court. What was she in this New York Supreme Court?
She worked for the First Department Departmental Disciplinary Committee.
She worked for the First Departmental Disciplinary Committee,
which is an aegis of the New York Supreme Court Appellate Division, First Department.
In other words, this is the entity that takes in the complaints against attorneys. Is that correct?
Yeah, including all those at the Wall Street District.
Including all those in the Wall Street District. So she's the one that is in an agency, a governmental entity that takes in complaints against attorneys, and she has blown the whistle on the process by disclosing that in that agency there was somebody who would be a gatekeeper or a cleaner, as she referred to them, if I'm not mistaken.
Correct.
That would clean the complaints against the attorneys or anybody, or I guess even U.S. attorneys were if somebody complained against a U.S. attorney or they complained against any attorneys, this cleaner would sanitize, I guess.
Not any attorney, just ones from what she said in open U.S. federal court were, quote, favored lawyers and law firms.
Okay, so
and
this
to
is
the Judiciary Committee.
Yeah, so this goes back. So this goes back to the good old boys club, the ones that are in the good old boys club, the ones that are anointed, the ones that are the favored attorneys, the ones that are from the big law firms, perhaps, or the ones that who are paying judges or are supporting judges' campaigns or whatever it is. They become favored attorneys, and when the complaints come in against those favored attorneys, the sanitizer would sanitize the claims before they would get to Mrs. Anderson's department.
Well, not only that, but if Mrs. Anderson's department had started investigating, we learned in court, they would try to force the investigator to change their complaints, or they would just actually go in, throw the investigator's report out, and put their own report in replacing the complaint, which is just unbelievable.
Right.
And then if the investigator, like Anderson, was complaining of that process, they worked to rub you out of your job. And in her case, they physically assaulted her.
Mm-hmm.
Her supervisor was sent to management counseling. But we're in the ethics department of New York talking about this,
right?
Which is just so mind-blowing.
Right. Well, it's not mind-blowing because, again, it goes back to the very theme or this
total desecration of the word law and everything sacred about it.
Right, and it's also a desecration of our constitutional rights, a desecration.
At the highest office, at the fail-safe.
Right.
These are supposed to be the fail-safes.
Right.
And they're actually committing the crimes.
Right, and this is organized crime at its highest level, and it's impossible to almost get your arms around because of the magnitude of the power and the ability for them to protect what they're doing.
Well, for example, when you said, these powerful law firms, first of all, they're not rogue lawyers and law firms. They're a coordinated RICO enterprise controlled of, several large law firms. Well, one of them that I'm, brought in with this Bill Dick from Foley and Lardner, who came in to cover up the Joao crimes and continued and perpetuated patent frauds. The key guy at Foley and Lardner was Michael Grebe, who's the former RNC chief counsel, and you can see what a wonderful job he did.
That's
to
the Republican National Committee. Is that who that is?
Yes, the Republican National Committee. So one of the most powerful men in the country,
right,
with one of the key jobs